Hey guys, this is John Farrell with the Farrell Law Firm. I wanted to reach out to you today to talk about a question that I get from time to time. But first, a little information about myself. As you may or may not know, I am the author of Estate Planning for the Modern Family, and I was also recently voted one of the top 3 lawyers in Cobb County, along with the law firm being voted one of the top 3 law firms in Cobb County. But one of the questions that I get from time to time from my clients is, if I'm establishing a revocable living trust, then why do I also need a last will and testament? Because after all, isn't the purpose of the revocable living trust to avoid probate altogether? Well, that is true, but we provide a last will and testament with every revocable living trust that we do, and there's a reason behind that. Mainly, the idea behind the trust is that you're going to want to take your assets and put them into the name of the trust, so they won't get frozen by the probate court when you pass away. But there's certain things that you can't put into the trust. These are things like your IRA or your 401k. But other things you can name beneficiaries to. You wouldn't necessarily put them into the trust, but you can name beneficiaries to them. These are things like your life insurance policies and your annuities. So you might make the trust as the primary beneficiary or perhaps the contingent beneficiary on that policy or that annuity. But the idea behind the trust is that you take your assets and you put them into the name of the trust. Well, from time to time, your family may find that you have assets that just were not put into the trust after you've established it. For example, let's say that 5 years after we help one of our clients set up a trust, they go up into Blue Ridge, they buy a cabin, and they simply forget to put that cabin into their trust when they buy it. That's an example of something that would be in their own name that would get frozen by the probate court once they passed away. Another example may be something like, let's say, for example, they pass away, but they inherit a piece of property from a relative when that relative passes away. So the client's passed away, but later on, one of their relatives passes away, and they've written a will leaving a piece of property to our client who has established a trust. Well, that piece of property was, the client was named as a beneficiary of that will so that that property would pass to them. So in that instance, after the client's passed away, there is something that will fall into their estate. Well, that's where the last will and testament comes in. Either they have forgotten to put an asset into their trust, or they inherit a piece of property that they wasn't expecting, when they passed away. Another example is, perhaps a client just simply forgets to tell their family that they've got an asset. Maybe they've got a checking account they really don't tell people about, and it ends up getting frozen. They never put it into the trust, and it's just frozen once they pass away. So there's a few examples of how assets wouldn't necessarily go into the trust or weren't put into the trust after the trust was set up, and it would get caught in probate. Well, that's where the last will and testament comes in. The last will and testament will then push those assets into the trust. Really, the only purpose of that will is to pour over those assets that aren't inside the trust into the trust. And that's why some places they call it a pour over will. We'll even call it a pour over will here in the office when we're talking with each other. But it is a last will and testament. I describe it to my clients as a safety net. They'll probably never need this will, but it's there just in case they have assets that are outside of their trust once they pass away. So every revocable living trust should come with a last will and testament that's designed to pour over assets into the trust that simply forgot to be placed into the trust or weren't placed into the trust when the trust was created, so that those things can be distributed out then through the trust provisions. So that's why you would need a last will and testament, even though you have a revocable living trust. That's a question I get from time to time. I just wanted to pass that along to you. Again, my name is John Farrell. I'm an estate planning attorney here in Marietta, Georgia. I'm glad to help you with your estate plan. If I can, feel free to reach out to us. All of our contact information is below.